Modi Cements Ltd v. Kuchil Kumar Nandi, 1998. Issue. Can a cheque bounce case under Section 138 of the Negotiable Instruments Act be dismissed just because the drawer issued a cheque with a stop payment instruction? This was the central question in the case of Modi Cements Ltd v. Kuchil Kumar Nandi, 1998. Judge, court is now in session. The complainant argues that the accused issued a cheque that later bounced due to a stop payment instruction. The accused claims that stopping payment should not be considered an offence under Section 138 of the Negotiable Instruments Act. Let's hear the arguments. Complainant's lawyer: Your Honour, our client received a cheque from the accused for a financial transaction. However, when they deposited it, the bank returned it with the remark payment stopped by draw. We argue that issuing a cheque and later stopping payment still constitutes an offence under Section 138 of the Negotiable Instruments Act, 1881. Judge, Defence Counsel, how do you respond? Rule. Defence Lawyer: Your Honour, stopping payment on a cheque is different from dishonour due to insufficient funds. The accused had a legitimate reason to stop the payment, so this should not be treated as a criminal offence under Section 138. The key legal question in this case is, does issuing a stop payment instruction on a cheque prevent liability under Section 138 of the Negotiable Instruments Act? Application. Judge, Complainant's Counsel, do you have any counter-arguments? Complainant's Lawyer: Your Honour, the intention behind issuing the cheque is important. A person cannot escape liability simply by stopping payment. If the cheque was issued to discharge a legally enforceable debt, then stopping payment is merely a way to avoid the obligation. Defence Lawyer: Your Honour, stop payment instructions are often given for valid reasons, such as fraud or disputes over the transaction. If the law treats all stop payment cases as criminal offences, it will be unfair to honest individuals. The Supreme Court had to decide whether a stop payment instruction should be treated as a valid defence or as an attempt to avoid legal liability. Conclusion. Judge, after reviewing the case, the court holds that a stop payment instruction does not absolve the drawer from liability under Section 138 of the Negotiable Instruments Act. If the cheque was issued to settle a legally enforceable debt, and the drawer later stopped payment, it still constitutes an offence. Complainant's Lawyer: This ruling strengthens the law. Now, stopping payment on a cheque cannot be used as a loophole to avoid liability. Defence Lawyer: This decision means that drawers must be careful when issuing cheques, as stop payment instructions will not protect them from legal action. Key takeaways. Stopping payment on a cheque does not exempt the drawer from liability under Section 138 of the Negotiable Instruments Act. If the cheque was issued to discharge a legally enforceable debt, the drawer can still be prosecuted, even if they later stop payment. The intent behind issuing the cheque matters. If there was dishonesty or an attempt to defraud, the drawer can be held guilty. This case set a major precedent in cheque bounce laws. That comes under Negotiable Instruments Act.